Hotep, I am the Amen Osiris, the one and only undisputed God of law. We are Deception Stoppers, America's only 4D education service. I'm not a lawyer. This is not a law firm. We don't advocate that you don't support your human offspring. We simply advocate that you made them in private, take care of them in private. Today, what I'm going to teach you is about a constitutional violation that anyone who was involved involuntarily in the 4D crime families scheme, what you call child support. Today, I'm going to show you how they inflict what's called a bill of pains and penalties. And basically, it's a bill of attainder. All right. Bill of attainder, which basically is the same. All right. What it does is it's a special act of the legislature which inflicts punishment less than death upon persons supposed to be guilty of treason or felony without any conviction in the ordinary course of judicial proceedings. All right. So the persons under Title 4D are called obligors, okay, or non-custodial pay rents. Legal fathers, biological fathers, putative fathers, all right, fathers, period. If you look up the word father, it deals with the contract. All right. So here you're going to see a recording from a 4D crime boss in Illinois, all right, who's going to be clearly explaining how they inflict these bills of pains and penalties upon you, which is a violation of the Constitution. All right. So what you have is bills of attainder. All right. It's the same thing. All right. Bills of attainder. In the United States, bills of attainders are unconstitutional as stated in Article 1, Section 9 and Article 1, Section 10 of the United States Constitution. Under 4D of the Act, a bill of attainder was the act of the United States Congress allowing defendants, which are the people who are inflicting, declare you an obligor, non-custodial parent, or non-custodial parent, allegedly guilty of not paying them, even without a valid Section 1 court order. All right. The most profitable and commonly used bill of attainder inflicted upon you as the plaintiff by the defendants was a 45 CFR 303.100 administrative wage withholding without a trial, all right, or due process. Article 9 prohibits these federal bills of attainder, and Article 10 prohibits bills of attainder by the states. So the state can't use either one. The constitutional ban on bills of attainder works to uphold separation of powers principles by preventing Congress from assuming the functions of the judicial branch. All right, it's already too late for that because under Title 4D, all right, you're gonna hear directly from the horse's mouth, all right, how and these bills of pains and penalties and these bills of attainder are being inflicted upon you, and not upon you, but who they're being inflicted upon. Okay, remember, bills of attainder target certain persons. You're going to hear that word twice in this video. Okay, let's get started.
Hello, I am Michelle Jochner with the Illinois State Bar Association, and this is Illinois Law. Our topic today is child support enforcement remedies, and our guest is Mr. Norris A. Stevenson, who is a Deputy Administrator of the Division of Child Support Services of the Illinois Department of Health Care and Family Services. Welcome, Mr. Stevenson.
Thank you. Thank you for having me.
Thank you so much for being here with us today and discussing with us child support enforcement remedies. Now, what steps does a child support agency take to collect child support which is due?
Well, the very first thing that we do, and I know some people think of it as an enforcement remedy, but we do what's called an income withholding notice.
Okay, the most profitable bill of attainder is a withholding notice. Okay. First admission, he's going to be admitting his guilt their guilt all through this video.
And the income withholding notice is a document that we send to the employer.
Okay. What law requires your employer to accept documents from this people?
It literally outlines the terms of the child support order and the frequency to which it should be paid.
All right. The terms of a child support order. Terms come from a contract. Look up the word term. Child support order can only come from the court. Okay, under the 45 CFR 302.34 contract between the court and the 4D crime family, all right, they are independent contractors and not agents or employees of the state or the 4D crime family. So where does court order come from? All right, keep going.
Once we've done that and and the employer has that information, they submit that information to the state disbursement unit where all of the process of getting child support to individuals actually happens.
What law requires your employer to give them information pertaining to you? All right. However, the other question is what law requires them to give information pertaining to the person who is subject to this bill of attainder? You're going to hear it in a second.
Okay, so when the income withholding order is unsuccessful and child support becomes past due, then what happens?
Oh, I'm sorry. Income withholding orders do not come from the court. They come from the 4D crime family. The alone, detached, and disconnected organizational unit operating in the state, which is outsourced by the federal government.
Well, we have a series of things that we call administrative enforcement remedies that we use.
Okay, administrative enforcement remedies. Now, remember that if you look up administrative remedies, that's usually for prisoners.
I'll outline a couple of those for you, some of which include.
All right, now let me show you, and I don't want to discredit my man in any way. All right, this is what he's going to be reading off to you. All right, these are the legal consequences inflicted and also prohibited by Section 1 and 9 and Section 1 and 10 of the United States Constitution, Bills of Attainder. And this is done by operation of law. So listen to him. Hope you can see it. All right.
Liens on property, passport denials, driver's license suspensions, income tax intercepts, which is one of the more common ones that you hear about. And all of those can be utilized when an individual has failed to pay his child support.
When an individual has failed to pay his child support. What is an individual, gentlemen? It has several definitions. One of the definitions that describes an individual is an artificial person in certain cases. Okay? Here, they are not talking about human beings, and you're going to find that out in a second.
Now, part of what happens, though, is that they don't happen automatically. Before we take any of those remedies, we actually send the individual obligor what we call a notice of intent.
Did you hear it? We actually send what? Let's go back. We actually send the individual obligor.
Send the individual obligor what we call a notice of intent.
Gentlemen, all right, an obligor, first and foremost, all right, I'm moving some stuff around. I'm trying to get creative with these videos to make sure we keep your attention span. All right, but this is an obligor. All right, according to the federal government, who oversees the 4D crime family in the state, obligor, what? The person obligated to pay child support, also referred to as what? Non-custodial pay rents. These are the persons subject to a bill of pain and penalty or bill of attainder. Remember, it only targets certain persons, which are obligors and non-custodial pay rents. Okay? If you're not an obligor, then why are you accepting mail sent to an obligor? That's obstruction of mail correspondence. It's also false personation of a public officer. Okay? You heard him. He said they noticed the obligor. If you look in the mirror, what are you going to see? You're going to see a man. All right? Proof is in the pudding. Go to the preamble of any state constitution. It clearly states we, the people of the state, are grateful to who? Almighty God for our religious freedoms and liberties, yada, yada, yada. All right? Genesis 1 and 26. God said, let us create man in our image and likeness. Man, the adult male, the human species above the age of puberty. Okay? So before I go on with this, all right, all you got to do is remember this. Okay? Remember this. Expressio unius est exclusio alterius. Expression of one thing is the exclusion of another. Okay? Mention of one thing implies exclusion of another. When certain persons or things are specified in a law, contract, or will, an intention to exclude all others from its operation is inferred. The other word is expressio unius persons est exclusio alterius. The mention of one person is the exclusion of another. Within the Constitution, if you see the word person, because the Constitution pays homage to Almighty God, and Almighty God, according to their Bible, created man in the image and likeness of other gods, all right, then you're not an obligor. Okay? You can go, all you have to do, more importantly, go directly to the statutes that were adopted in the state. Okay? They were adopted to get their state plan approved and adopted to get federal funding. So they adopted it from the feds and they put a state spin on it. It's the same garbage. All right. So their law only, all right, bills of attainder are only inflicted upon obligors. You keep putting yourself in the obligor's place. Somebody said to me, "Oh man, they're forcing me to use my social." It's not your social. All right, Social Security card is the property of the Social Security Administration. They can do with it as they will. You're the one who keeps getting caught out there with it. All right, let's continue with this confession.
And that notice of intent literally outlines to him that we are contemplating taking some of these enforcement remedies against him to pay the past due support that hasn't been paid.
Against who? The obligor. All right, it's coming up again. Listen.
Once we've done that, they get the opportunity to contact us and tell us whether or not they think that we're right in the actions that we're taking.
Now, there you go. Check this out. One of the biggest issues in what you call child support, I hate using that word, is the fact that there's a case. There's a 4D security interest, what you call a case number. Look up the word security interest and you'll see what I'm talking about. Okay? So anything connected to that case, which is basically the social security number that you've been using, okay, it's going to affect you somehow, some way. So basically, when it comes time to shoot these people, okay, Title 4D is what? It's a service. Did you apply for the service? No. Okay. Do you want the service? Obviously not. So why not just tell them, hey, tell you what, I never applied for Title 4D services. I don't want Title 4D services. So you can terminate that and leave me the hell alone. So that's how you make contact with them. I'm going to give you, and then you tell them, I'll give you 10 days. All right. And in the meantime, while you're doing that, at the same time, you're drafting your lawsuit, all right, articulating on how you're suing them for this bill of attainder. Okay. And, you can go from there. All right. That's how you contact them. Then the next step after that is you hit them with a lawsuit. Let's listen.
Or to make some arrangements to have the payments that they were behind actually done.
Okay. So now, is the child support agency required to go back into court to enact its enforcement remedies?
The administrative remedies, no.
All right. Look, the administrative remedies, no. What is it? It's a bill of pain and penalty because it's without any conviction in the ordinary course of judicial proceedings. He just admitted it, and she asked the perfect question. Let him continue.
I mean, through PEROR, which is the Personal Work Opportunity and Reconciliation Act that was passed by the federal government, it provides the child support agency with a gamut of tools that it can actually use to go forth and do collection activities.
All right. So what they did was Congress, all right, these people, what they did was now they're allowing them to separate powers here. The constitutional bill of attainder works to uphold separation of powers principles by preventing Congress, that's who he said, the federal government, from assuming the functions of the judicial branch. All right? There's his admission right there. Gentlemen, you want to be free, it's right in front of you. Okay? Let's let him continue with this confession.
And most of those don't require us to go through the courts to get those done. We literally have to notice the individual and move forward to do those.
Notice the individual. What notice are they? What individual is getting this notice?
Okay. So now, are there thresholds which trigger the use of by you of enforcement remedies?
Sure they are. For just the basic remedies, and basic remedies include things such as income tax interception, things like that.
All right. Now, let's look at the word. He said administrative remedies. All right. So let's look at what administrative remedies means. Oh, wrong one. I have it around here somewhere. Oh, here it is. All right. Okay. Also, gentlemen, if you need a Zoom consultation, all right, and 4D literature, contact me, Ahmed Osiris at hathorset@gmail.com. We will get back to you and we can meet face to face and tell you and help you out. So this is the definition of the word administrative. All right, administrative connotes or pertains to administration, especially management, as by directing or superintending the execution, application, or conduct of persons or things. Remember, the obligor is what? The person obligated to pay child support. All right, so this administrative notice is over the obligor, which is a person and it's a thing, particularly having the character of executive or ministerial action. What branch of the government is the 4D crime family within? Right, if they're within the executive branch, usually the Department of Social or Human Services, and in certain states under the Attorney General or Department of Revenue. You know, it's one or the other. All right, but these are umbrella corporations. An umbrella corporation or an umbrella agency is an employer to agency contractors who work on a fixed contract term assignment. All right, you gotta learn your stuff. All right, so it's executive, it's ministerial, it's not judicial. In this sense, administrative functions or acts are distinguished from such as are judicial. Again, a bill of pain and penalty. It's without conviction in any ordinary court or judicial proceeding. All right, this guy is just admitting he's a crook. They're crooks. Synonymous with executive. All right, the executive, judicial, and legislative branch shall forever remain separate, and no person from one branch shall perform the duties of another. That is the separation of powers. And guess what? So if it ain't judicial, where'd the order come from? I'm telling you, fellas, you got to pay attention. All right. And we're going to get back to these individuals.
The threshold for us to take any of that kind of action is $150 on TANF and foster care, cases that have a public assistance.
All right, cases. So at minimum, if your woman's on welfare and they're coming after an obligor and you're representing that obligor and letting them take your money, okay, if $150 comes up missing out of that pay, they're automatically going after you. That's Title 4A. That's welfare. Title 4D is different. Listen.
Tinge to them. On other cases, non-assistance cases, the threshold for enacting those remedies is $500.
All right, Title 4D is 500. Title 4A is 120. So after those thresholds, that's when they start doing shit to whom? The obligor.
And then within those remedies, some of those special enforcement remedies have other thresholds that they use.
Now, we showed you what administrative was. All right, it has control over certain persons, which are obligors. All right, it's executive, it's ministerial, it's distinguished from court. All right, it's a bill of pains and penalty. Let's look at the word remedy. All right, remedy. Now, first and foremost, gentlemen, if you don't know your Supreme Court rulings, such as Blessings versus Freestone, Hunt versus Ledbetter, Mason versus Bradley, there's tons of vital information in these case laws, especially when it comes to Blessing versus Freestone, where the United States Court clearly stated that Title 4D was never intended to benefit individual children or custodial parents, all right, far from creating any individual rights. So there's no right to Title 4D. Okay, I want you to realize that because I'm about to read you something. Furthermore, there's no, they're not obligated to give you the service. All right, we don't have to do anything. They'll tell you. You get nothing if we don't give it to you. So, remedy, okay, and you're going to see why, means by which a right is enforced or the violation of a right prevented, redressed, or compensated. Remedies of our four kinds. Now, number one, we already know that there's no right to child support. Okay? So there can be no remedy there. All right, so one of the four remedies is, look, by act of the party injured. Well, there's no injury, so that one's done. All right, number two, by operation of law, as in the case of retainer and remitter. So look at those words, retainer and remitter. Operation of law, 42 USC 666 A3 AC4 means by operation of law. Okay. Furthermore, everything that he told you, these wage withholdings and all this stuff that they do, all this stuff down here. Okay, these remedies. All right, these are all done by operation of law, minus the federal imprisonment or fines or both. All right, but everything on top of that, 1 through 9, 9 through 1, however you want to do it, these are all done by operation of law, without jury, without judicial. Okay. These are bills of attainder. They are not remedies. Okay? They are not remedies. Remedies have to come from a court. Case in point, the court shall be open to every man for injury done him, his lands, goods, reputation, and he shall have remedy by due course of law without sale, denial, or delay. Okay? That's constitutional. He shall have remedy. These are remedies, gentlemen. There's no such thing as administrative remedies. You can only get remedy from a court, but they're doing it under operation of law. And if you look up the word operation of law, which means basically they can do whatever they want, and the party that they're inflicting this bill of attainder on can't say anything about it. Why? Because it's an obligor. It doesn't have rights. Okay? Let's go.
For example, for driver's license suspension, the individual has to be behind $2,500
The individual what?
and not have made payments in the last 90 days. So there are a series of other thresholds that come into play with the particular remedy.
All right. This driver's license suspension. All right. Check this out. That's not done by court. It's done administratively. And believe it or not, the driver's license administration has a contract with these people. And they're getting a taste of it because every time they suspend the license, you got to pay that restoration fee. Telling you, boy.
But all of those start with the notice of intent to pursue that I suggested to you earlier.
Now, here's the deal. They are required to provide an obligor due process of law. All right. So by that, due process of law means the right to know of an action being taken against you. If the due process fails because the due process, well, it doesn't fail, you fail. The due process is for the obligor. So if the motor vehicle sends you a notice, right, and you take that notice, you don't open it, you put her in a bigger envelope, and you send it back, right, care of your home address, you can use the zip code on that one, right, you send it back certified mail, then you get the green slip back, says, okay, they received it. What that means is the obligor never received that notice. So if they suspend that license at that time, you have a valid get out of jail free card. When you accept it and open it, all right, number one, you're not an obligor. So if you stop being an obligor and start sending back mail that's intended for the obligor certified, all right, a lot of this stuff won't happen to you.
Okay. So now if an obligor objects.
If an obligor objects. So, gentlemen, this is what I will explain to you again. First and foremost, now she said it. If the obligor objects, I'm going to let this play out.
Or disagrees with your action, what should they do? What course can they take to set forth their objection?
In many of the remedies that we do, there are steps that are laid out on that notice.
Okay. More importantly, because you never got the notice, why don't you basically, if there's a case, it's tacked against the Social Security number that you're using, gentlemen. The objectivity is to get that case terminated. The easiest way one of the easiest way, and a counter technique, again, the mention of one thing is the exclusion of another. So number one, you need to be expressing, listen, I'm not sure what this is about, but I'm not an obligor, and I'm not this person, And I do, regardless if you utilize that number or not, okay, I need you to terminate this because it's affecting me adversely. And I'll give you 10 days to do so. Okay? If you're going to communicate with them, do it like that. Make sure the all caps name on there and the 4D security interest numbers on there as well. Let's go.
So if an individual disagrees with the balance that we say that we're pursuing, they have an opportunity to contact us and literally work with us to clear up that.
All right. There it is. That's your remedy. So if they're wrong, you don't owe them a dime. You're not an obligor. You're not an individual. Okay. You're not obligated to pay these people. Okay. He just said you have an opportunity to do that with us. Okay, bam. You create, and now this is what we do. Now what you do is you go in and you take their shit and you use it against them. They can't come back and say that you're wrong. All right, but I'm gonna show you a real easy technique. We're almost done.
But all else being, if that fails, the individual has the right to appeal the action that we're taking.
No. All right, the individual, the obligor, has the right to appeal. Once you tell them and explain to them and prove to them on paper that you are not, in fact, the obligor, by using their statutes, their words, their definitions against them, beyond a shadow of a doubt, not to mention a sprinkle of Constitution, preamble, and Declaration of Rights, guess what? I already proved to you. I told you I'm not the obligor. I just proved to you on paper. I'm going to give you 10 days to terminate this. If not, I'm going to sue you. And they think that they can get over on a lawsuit, and they can't. Not anymore, gentlemen. Sorry for the noise. Let's go.
And they simply need to contact us and ask for an appeal. We'll ask them why they're appealing or the nature of their appeal, and then we'll give them a process for how they do so.
I don't think so. All right. When you contact them, explaining to them that you are not this obligor, all right, ain't no appeal. All right. I'm telling you, I'm not the obligor. You got 10 days. On the 11th day, I'm suing you. And on the 11th day, you're filing a lawsuit. You're serving him or her papers, all right, from a process server, all right, and you're bringing an action against them. Gentlemen, if you're going to hit them, hit them. Okay? Don't wait 6 months after you. Oh, well, they didn't respond. Okay, you gave them 10 days to terminate the case. They didn't terminate it. Take your ass down to that court building, federal court, and sue them for deprivation of rights under color of law. Let's go.
Ultimately, they'd end up with a hearing in front of one of our administrative law judges.
Administrative law judge, gentlemen, is not a real judge. They are in the executive branch. You think they're going to rule in your favor? I don't think so.
That literally will allow them to take the steps or address the issue that they're bringing before us.
Okay. Well, Mr. Stevenson, thank you so very much.
Thank you, Mr. Stevenson, for spilling the beans. Gentlemen, so now you know that you're not an obligor. Now you know you shouldn't be accepting mail for an obligor. You're not a person. A person is not such because he is human. A person is the legal subject in which rights and duties are attributes. Subject to what? Okay, you don't want to be a person. Black's Laws Dictionary, page 1300, fourth revised edition, of course. All right, so you're not an obligor. So these administrative remedies are being inflicted upon an obligor by operation of law. You heard the word obligor or individual and, of course, person. Okay, so here's a nice little counter technique you can use. All right, and this, let me see if I can get it here. And again, for consultations, contact us at hothorsec@gmail.com. All right, and this is the 45 CFR 303.11 non-custodial pay rent case closure counter technique. And under this technique, all right, the 4D agency shall establish a system for case closure. The 4D agency may elect to close a case if the case meets at least one of the following criteria and supporting documentation for the case closure decision is maintained in the case record. Okay? Number 7, the non-custodial pay rents location is unknown. Okay? There it is. The non-custodial pay rent, otherwise known as the what? Where is it at? The obligor. Same thing. Non-custodial pay rent or the obligor. All right. Once you prove that you're not the obligor, then you're giving them permission to terminate this case. Look, under here, after 1 year period when there is sufficient information to initiate an automated locate effort to locate interfaces are unable to verify social security number. Gentlemen, all right, don't get it twisted. The obligor non-custodial payment is positively identified by that social security number. Okay? But this is a case closure technique. Okay? Clearly, number one, they're inflicting bills of attainder upon an obligor. You keep volunteering to be the obligor. Stop being the obligor. Okay? Prove that you're not the obligor. But you also have the option, which I advise, all right, because you didn't realize that, this newly discovered evidence proved that you were basically providing commercial energy. Now you can sue them. All right, everything that they've done to you, you can sue them for a bill of pains and penalties. It falls under deprivation of rights under color of law, color of office, and color of authority. I'm the Osiris, gentlemen. Okay, hope you're enjoying this new cut because it's on and popping this year. And again, I'm going to say it again. If you need a Zoom consultation, all right, check us out. If you need 4D literature, all right, for a small donation, I can get you either or. All right, and we will get you where you need to go. All right, gentlemen, you don't have to reinvent the wheel. All the information that you need, all right, to get rid of the 4D crime family that's in your life it's right in front of you. All right, this little video that I'm putting in here right here, guess what? This you're done. You can take this right here and finish it off today. All right, you need help? Bang the email. All right, and we'll get you squared away. I'm the Osiris. Appreciate you. Hotep.